Hello, and welcome to this quick discussion between me, Corinne Staves, a partner here at CM Murray, and my partner, Andrew Pavlovic, a partner here at CM Murray as well, with a specific focus on SRA regulation, which is one of Andrew's really true areas of expertise. The reason we decided to have this chat was actually because last week was the SRA's annual COLP and COFA Conference. It's a great opportunity for COLPs and COFAs and law firm leaders to join together to talk all things risk and compliance, but specifically because it's arranged by the SRA to hear from the SRA about what their strategic priorities are for the year to come, to hear them reflect on the year gone by. And this year is a particularly interesting one because we've just had the LSB's report into the SRA's handling of the Axiom Ints matter. Let's not give it any inference there. And I wondered, Andrew, if you could just give us some thoughts on that LSB report, which didn't shine the SRA in a particularly positive light. What did they have to say about that?
Yeah, so they found that the SRA had failed to adequately supervise the situation. So just to give a brief recap, Axiom was a relatively small firm with one individual held all the compliance functions, and they acquired two firms in distress, Ints and Plexus. And the SRA had actually previously inspected Axiom in November 2022. There were criticisms of the way they handled that inspection. They didn't follow their usual procedures. And then when Axiom acquired these two firms, they said that the report said that the SRA didn't really focus much on Axiom and its role. They were sort of focused more on the two firms in distress, because obviously those two firms are in correspondence with the SRA to say, we're in financial distress, this is what we're doing to manage the risks to clients, etc. And the SRA's focus was on that rather than sort of, hang on a minute, how is this small firm being able to acquire these two much larger firms? And we now know that they were doing that with the use of client money, and around £64 million has gone missing. And the compensation fund is ready to step in, and everyone's compensation fund contributions has increased as a result. So the LSB's main conclusions were in failure to adequately inspect in November 22, failure to assess the risk of Axiom as an accumulator firm adequately. They did do a risk assessment, but it wasn't robust enough. And then failure to really consider their role as the acquiring firm in those acquisitions. The SRA's response was quite punchy, effectively saying, well, lots of people missed this fraud, including the accountants and auditors. It was a complex fraud which is being investigated by the SFO. And whilst we admit there were some failings in our procedures and processes, there's no evidence to suggest that if we had taken those extra steps, we would have been able to spot the fraud any earlier than they eventually did. And the report goes on to make a number of recommendations, including, for example, that the SRA should be conducting more random inspections or more targeted inspections in relation to firms' clients' accounts. They should be requesting or seeking rule changes to require firms to change their accountants regularly, so that there's a greater chance of things being spotted. And there's also discussions around their roles in mergers and acquisitions, which potentially we can chat about later. So yeah, it was quite punchy from the SRA generally, and at the conference as well. They sort of maintained that line. I think Paul Phillips said, the report was the author's opinion, and that they'd already made a number of changes to their processes following this whole saga. And Anna Bradley, the chair, described this sort of as old news because they'd already implemented the changes. So still quite sort of indignant at the moment.
Yeah, I can imagine that wasn't particularly well received by the attendees, who were perhaps looking for a little bit more contrition, perhaps in the messaging, if not sort of accepting that maybe work had started already on remedial steps. Let's if we can just focus on that aspect you raised about sort of consumer protection, and I think particularly as I understand it, there's going to be quite a strong focus on client accounts. Do you have a sense of what that consultation will focus on and what steps we might see?
Yeah, so the consultation is apparently going to be published this week, hasn't been at the time of recording this. And the three main areas were firstly the point about, should solicitors still hold client money at all? Should we have sort of third parties holding funds? The SRA sort of recognised that that's something that couldn't happen overnight because there just isn't the infrastructure there. and that these third-party providers will need time to build up the resource and the capacity. So that's more of a longer term issue as to whether or not it's sensible for firms to continue to hold client money. And you can imagine that some areas, such as conveyancing, that's where transactions are going for every day on the basis of undertakings. There's potential for disruption if firms don't have the direct control of the client account. So it'll be interesting to see how firms respond to that, whether they do say, no, it is necessary for our day-to-day job to be able to have easy access to client funds, or whether they agree. There's already been a survey that I saw in which the vast majority of people responding said that they thought the solicitor should continue to hold client money. That was a survey of firms. The second part of the consultation relates to how the compensation fund is funded. So at the moment, all firms pay the same amount, the same contribution, irrespective of size. Obviously, the larger firms do effectively pay more because they have more individuals, and so they have to meet the individual contribution. But the question Paul Philip raised last week was whether that was fair, whether larger firms should pay a larger firm contribution, recognising that they also end up paying more for the individual contribution, and recognising also that quite often it is the smaller firms that end up with problems and end up having to sort of be the beneficiaries, as it were, of the compensation fund. So it's a difficult balance. And the third area is around accountants' reports. So at the moment, the SRA only see an accountant's report if it's qualified by the accountant. So if the accountant says, something hasn't taken place in accordance with the SRA accounts rules, the report is qualified and it's submitted to the SRA. And this was also a recommendation in the LSB's report that potentially we should switch to a situation where all firms have to provide their accountants' reports to the SRA annually. Again, all of these things, when we talk about all these things, what we're doing is potentially giving greater power or greater scrutiny to the SRA, which involves more time and cost at their end. So, it's always a difficult balance between regulating effectively and sort of overburdening regulation. And, arguably some people say it's gone too far the other way with the principles-focused regulation and some of the changes they've made. The SRA at the moment are saying that they don't consider all of these powers that the LSB have mentioned in their report to be necessary. And it's about more focused regulation rather than just more regulation for the sake of it. So we'll have to see where it ends up.
Yeah, that's really interesting because one of the regular criticisms of the SRA is obviously in relation to a number of matters that you often experience significant delay, for example, if reports are made to the SRA and those sorts of things. And that seems to be an issue of resource within the SRA as much as anything. And obviously the increased burdens that you've been referring to, they'd have to accommodate that somehow, which would cost. And so, where would that land? Which I think we know the answer to that question already. Sticking on the theme of criticism of the SRA. No, I'm sorry, I'm being flippant. But obviously, one of the areas where they have been subjected to some scrutiny is around sort of the increase of fining powers and so on and so forth. Did they talk about that at all last week?
Yes, they did. So they've just closed the consultation regarding proposed increases and changes to their fining powers. So this was prompted by the fact that under the new Economic Crime and Transparency Act, they have the power to issue unlimited fines in relation to cases relating or involving economic crime. So it was setting out their position there. But there were also other changes that they talked about, such as introducing minimum fines for law firms, taking into account firms' global turnovers rather than just their UK turnover when setting fines, removing the credit that you get for cooperating with the SRA when assessing a fine on the basis that cooperating with the regulator is a regulatory obligation, so you shouldn't get credit for that. So in general, sort of tightening of the screw, I would say, and upping the ante. And it was received quite negatively. There was lots of negative feedback to the consultation. And the SRA have said last week that they'd taken that feedback on board. They were going to sort of go away, look at the rules again, and then potentially reconsult on them before they introduce any amendments. So I think perhaps given the current climate, it wasn't the right time for them to be increasing their powers in such a sort of exaggerated way. And I think they're going to go back to the drawing board on that.
There's obviously, if we've identified a bit of a theme here, also been some scrutiny on the SRA around the suggestions on fining powers and the increase to fining powers. Did they talk about that at all at the conference?
Yes, they did. So they closed the consultation relatively recently in regard to their proposed changes to their fining powers. So some of that was prompted by the fact that they now have powers to issue unlimited fines in cases relating to economic crime. So there was a need to say how they were going to sort of exercise those powers. But alongside that, they also proposed some other changes, such as introducing minimum fines, taking into account firms' global turnover rather than UK turnover when assessing the level of fines, removing as a factor to get as a sort of a mitigating factor, cooperating with the SRA, because they say actually cooperating is a regulatory requirement. So it's generally sort of just a tightening of the screw and upping the ante on firms, really. And it didn't go down very well. There were lots of negative responses to the consultation. And Pavlovic acknowledged those and said that they were going away, looking again at the changes and potentially reconsulting on them before anything is actually brought in. So that's positive. I mean, it shows that they are taking on board the feedback, and hopefully we'll see something a bit more measured when the sort of revised proposals are issued.
Another thing that I found really interesting in the LSB report was its commentary on sort of the control that the SRA exerted over mergers, and obviously one of the key takeaways from the report was that the SRA's approach left something to be desired in terms of being able to catch the issues that we saw in Axiom and the sort of the oversight it had of merger activity in the legal services sector. For what it's worth, I would agree that their approach doesn't seem very coherent. It seems to depend on what type of structure you go for, in terms of the extent to which the SRA ever needs to notify or approve sort of combination style activity, acquisition behaviour, and that sort of feels to be the product of a different number of approaches coming together than being one sort of deliberate strategy. So I would certainly encourage them to sort of think about what works well and what's proportionate. I think we need to be careful that we don't go too far along that line, because I think that anything too burdensome could be have a detrimental effect on positive activity in the sector. Which most merger activity is, frankly. It's about firms managing their risks and being more successful. So we need to just keep that in mind. And therefore, I think whilst sort of a cohesive approach to regulation would be welcome, we just need to think about that. And the other thing I would just add on that is that quite often merger terms are not sort of agreed finally or signed off until quite far along the process. So if the SRA introduced some sort of obligation to notify quite a long way in advance of the merger, or some kind of pre-approval process, I think that would be really quite stifling of that activity and would have a significant impact on the timetable and therefore the cost of these transactions. So it's going to be something that they're going to really want to balance and think through carefully before they have a sort of immediate reaction to those comments from the LSB.
So just on that, Pavlovic did say, it would require massive upskilling and substantial resources if individuals were going to be involved in sort of approving mergers or getting involved in that. And the usual time scale you get whenever you submit an application for authorization for a new entity or a new role holder is 30 to 120 days. So as you say, that would have to be factored in as well. So time, cost, all of that needs to be balanced with, as you say, maybe taking a bit more of a cohesive approach to these things.
And that just wouldn't work if, and not all mergers are driven by distress, but some merger choices are driven by distress, or something like a PI renewal deadline, or something like that, a specific event, and therefore there wouldn't be the luxury in those timetables to be able to allow the SRA to make decisions in those sorts of timeframes. So absolutely, Andrew, I think that's a really good point too. Just before we sign off, one key focus for the SRA and for our clients has been sort of workplace culture and all the changes that have been required to accommodate their new guidance on and the new obligation under the code. Were there any, I know you sort of attended a session on workplace culture, sort of a where are we now session. Were there any specific sort of takeaways that it's worth sharing just before we sign off?
Well, I think in general there was a recognition that the rules have at least forced firms to think more about workplace cultures and workplace behaviours, and that increasingly these sort of things are being viewed from the risk and compliance lens rather than just as from an HR perspective, and that was considered to be positive. The SRA did conduct a number of visits to relationship managers' firms towards the end of last year and the start of this year. And there was a bit of a discussion about some of the themes that had arisen during those discussions. And one of them was in relation to recording challenges, which is something I've got a bit of a bugbear about, and it comes up a lot in the training we do. So again, the message from the SRA at this conference was that not every challenge needs to be recorded. You know, it's about creating the right atmosphere in a firm where people will pull each other up if someone thinks they've crossed the line, and it's not about then going away and recording everything in a register or making it really formal. It's about more of a sort of cultural thing. That sort of contrasts with their guidance, which says, you know, when you challenge, you should consider how it should be recorded. And the risk to firms, if they're not recording these things, is you might fail to pick up trends or in behaviour, or failure to spot sort of issues if everyone is doing their own challenges and there's no sort of centralisation. So that remains an issue. And it was interesting that it came up because it's certainly something that we've grappled with when we've been looking at this and talking to firms about implementing these rules.
Finally, again, just quickly, I know that you've been thinking a lot about the visits that there have been with relationship managers, and was there anything else that from that exercise that sort of chimes with that workplace culture comments that you heard at the conference?
Well, I think that the relationship manager visits were overall fairly positive, and I think most of the firms that took part in them that I'm aware of said that there was quite a lot of data to be provided in advance, but it was more about, you know, learning about best practice, what works, what doesn't. And there were some good tips actually at the conference about how firms can measure culture, because we think about it as being something that's immeasurable, really. It's something a bit sort of intangible. But they were talking about how you can look at things like, do departments have high rates of absence? Do they have high rates of turnover? Are there themes that you can pick up on and identify potentially as risk areas or areas where the culture might require looking at? I mean, it might be completely reasonable reasons why a department may have a high rate of absence for a particular period or a high rate of turnover, but just there are things that you can actually do to look at to try and measure these things and to take a broader look at it. So I thought that was an interesting point that came up.
That's really interesting, and what a great positive note to end this discussion on in terms of sort of the positive things that we can focus on as regulated law firms. Thank you, Andrew. That was a really interesting whistle-stop tour of some of the things that the SRA is sharing with us at the moment. Thanks for joining us, and if you've got any questions or comments in relation to any of these themes, then do reach out to me or to Andrew or to any of the other members of the CM team. Thanks very much. Bye-bye.